Hi, everybody. Thank you for joining us this afternoon. Folks are just filing into the virtual Zoom room here, so we'll give them a few minutes. As you wait, you should see a poll question on your screen if you'd like to provide an answer, and we'll begin momentarily. Great, and we still have people filing in, so we'll give them another minute or so. For those of you who missed what I had just said, should be a poll question on your screen, so please feel free to provide an answer, and we will be getting started here momentarily once everybody's in their room. Great, looks like we're gonna have a large crowd here, which is fantastic. So just another few seconds here and we will get started. All right, and for anyone who hasn't yet answered the poll question, you've got another few seconds to go ahead and provide an answer if you'd like. And okay, it looks like most folks have found their way into the room, so we can go ahead and get started. First of all, thank you for joining us for today's session on the impact of privacy regulations on social media and retargeting. My name is Mark LaFleur, and I'll be your Wire Wheel host for this session. Before we get started, I'd like to cover a few housekeeping items. You should all see the results now of the poll. Thank you for all those who participated. Also, please note that the views expressed here today by our speakers are their own and not the views of their organization. And last but not least, we do hope that these sessions will be interactive. So please submit questions via the Q&A feature in Zoom at any time. Please do not submit your questions via the chat box, but through the Q&A button. And with that, I'm excited to introduce your moderator for today's session, Maureen Mahoney, as a policy analyst at Consumer Reports. Maureen, I'll pass it over to you to introduce our panelists and get started, and I'll be back at the end of the session to help wrap things up.
Hey, thanks, Mark. I am so excited to be here today to talk about privacy regulations and their impacts on social media and retargeting, given the new California Consumer Privacy Act, the recently passed Proposition 24, and the potential for additional legislation in this space. This is a very timely topic, and we have a fantastic panel here today, people from all different perspectives ready to weigh in. So let's kick things off and get started with introductions, and I'll turn it over to Andy.
Hi, everyone. I'm Andy Dale. I'm the general counsel at Alice, which is a sales and marketing and gifting platform. I also am the host of a 80s themed data protection podcast called the Data Protection Breakfast Club with my friend Pedro from Facebook. And prior to that, I was the GC at a company called Session M, which is loyalty marketing platform. And prior to that, at an ad tech company called DataZoo.
Oh, wonderful. Well, good afternoon to everybody, and good afternoon, and thank you to our panelists today. My name is Osman Haas. I'm manager data privacy for BBB National Programs. BBB National Programs is the home of a dozen leading self-regulatory organizations. It's a place where businesses go to enhance consumer trust and consumers are heard. My program is a digital advertising accountability program, which is a self-regulatory unit which monitors the ad tech ecosystem for compliance with best privacy practices in the form of the Digital Advertising Alliance's principles. We've had 124 public privacy actions since the program began, and in my capacity, I also advise BBB National Programs on some of our new privacy initiatives, including yet to be officially announced new program on teenage privacy.
And hi, I'm Mark Zwillinger. I'm the founder of Zwilgen, which is a law firm in Washington, D.C. We have about 30 lawyers, and we specialize in privacy and security. Been around for 10 years. Before that, I was the head of practices for privacy and security at two large firms, Dentons and Kirkland and Ellis, and I started my career as a computer crime prosecutor in the Department of Justice, and we mainly advise technology companies and media companies, publishers, ad tech companies on privacy regulations. So it's a pleasure to be on this panel, and I look forward to our discussion.
Thank you. And I'll give a little bit of background on myself. I'm a policy analyst in Consumer Reports San Francisco office. Most people are familiar with Consumer Reports with respect to our magazine and our testing, but we also do advocacy work where we push for strong pro-consumer legislation in the areas of financial fairness, product and food safety, and in digital rights. And our testing informs our advocacy work. We've been pushing for federal and state privacy legislation for years now. And we've also been focused on the CCPA, trying to test that out, seeing how it works for consumers, helping consumers submit opt-out requests and reporting back what we found. We've also started a project as an authorized agent submitting opt-out requests on behalf of consumers. So we have found some difficulties that consumers have experienced in exercising their rights under the CCPA, and our work has been to try to make that as easy and effective as possible. And one of the particular areas of interest is, with respect to the opt-out, is targeted advertising, the extent to which the opt-out covers that. So I'd like to start off in that vein. Turn it over to the group. How are companies responding to the CCPA with respect to retargeting?
Well, I think at this stage, a lot of companies are attempting to look at what the definition of sale is and what their characterization under the statute is, whether they're a business, a third party, or a service provider. I think in the ad tech ecosystem, a lot of companies are opting for the service provider characterization, which I believe under the statute is a result of a contract between the business and the entity where it defines the personal information that's exchanged and ties it to a business purpose, depending on the contract. And I think that's, as I understand some of my stakeholders, I think that's the safest position that the ad tech companies have been trying to characterize themselves as. I think certainly in the social media space, I believe that Facebook is attempting to characterize itself in that position.
Andy, I was going to let you go next so I could counterpoint afterward. But
I don't have a ton to add there. I mean, I think that's generally true. I think people are, I think the only thing I would add is that when I talk to colleagues and I talk to my peers, I just think there's a lot of different thoughts about the different roles and what that means to be one of those roles and what position you're going to take. And this is such a technology, a complex technology ecosystem that the decisions that you make with respect to a designation like that, they're not so simple. And so it often requires a cross-functional group inside of a company between marketing, product, all the way up through the leadership team to discuss and have a serious strategy decision. So as you can imagine, those don't happen quickly, so that you're having to talk through and think through all of these things, and then also do that in Alice's case, in some ways with respect to the product roadmap itself for the actual company itself. So irrespective of any marketing activities you may be doing just for your business. So I don't know that I answered anything other than to say that it's exceedingly complex and is going to take people some time to get to their designation, I think.
Right.
Well, I thought you were going to stake out a position that we've heard from a lot of people, which is that the CCPA prevents retargeting in a lot of circumstances. So I was going to respond to that, but I think we're maybe all more aligned. I would say on the question, and just quick disclaimer, I'm a lawyer on the panel, but I'm not your lawyer, so I'm not giving legal advice to people in the audience at this point. But the CCPA obviously doesn't prevent anyone from retargeting. The question is whether retargeting becomes a sale under the CCPA or not, and whether you have to apply a do not sell to it. And our view on that, or my view on that, generally is that there are lots of reasons why it's not a sale. Retargeting is not a sale. I think the two clearest reasons are, you're paying somebody in order to help retarget your own customers. The benefit isn't flowing to you. The benefit is something that you're providing to somebody else. You're not selling data in that sense. You are paying somebody to be a service provider in order to retarget your customers. And the second point is what you were touching on before, which is that the retargeter platform is agreeing to function as a service provider. If you're looking at like the Facebook custom audience or Facebook pixel, they have agreed through their terms to meet the definition that's set forth in the CCPA to be a service provider. I think we're going to get into a much more interesting question when we talk about whether the CPRA prevents retargeting, and we may have some different views on that. And certainly, Alistair McTaggart will probably have a different view than I do. But on this question, I do think you can continue to find ways to retarget your own customers under the CCPA without necessarily having the do not sell apply to it. If you're working with service providers who have that functionality and agree to those contractual terms.
And ultimately, I do think a lot of the clarification surrounding these issues with the definitions in the statute and with the characterizations, they're going to depend on what the enforcement actions look like. If the California AG issues an enforcement action or a few enforcement actions, or if the new privacy agency that'll be enacted, that'll be founded as a result of the CPRA issues its own enforcement actions, clarifying some of these practices. I think we're kind of in somewhat of a murky territory where the universe hasn't been completely defined, but I think those are going to be that's going to be where we begin to see certainty when enforcement takes place.
Right. We'll also see some more, I think, certainty when we get the second round of regulations from the Attorney General's office before this gets passed off to the new privacy agency, because they did not take up the regulations on what constitutes sale in the first round. And they're supposed to be doing that in the second round in July
Sure.
2021. And that might put some insight on the definition of sale. Because we're all kind of assuming it is the broadest possible reach under the statute. It may not be. It may not be quite as broad as some people think.
I think it's a good call out, Mark. The regulations, specifically with CPRA, calling out cross-contextual, will put that squarely into the reg, and into a need to be addressed. And so, I agree with both things that you each said. That's where we're going to get clarity. Step one, step two, and then and just contextually across our peer set and seeing what other people are doing.
And I just wanted to dig a little bit further into what Andy was saying. From a consumer perspective, I'll go to a company, I'll click do not sell, and I expect, that it's simple, that companies aren't going to sell my data anymore. So what are some of you said it's really complex. What are some of the challenges that companies have been facing in the background as they've tried to implement that?
I think the big thing is the breadth of the definition of sale. I mean, it encompasses every single word almost related to the movement of data in any way. So making data available, in some contexts back to the customer that asked you to do something for them. So it's again, we need to see what the regs around CPRA say, because that'll be interesting. But I think what it leads to, Maureen, is just having to be really, really thoughtful about exactly what moves you're going to take. If you have a do not sell button and you're effectuating that and you're flowing that through, what exactly am I going to do? And it sort of relates to my earlier point that it's this cross-functional team approach now. Privacy touches everything in the organization. It used to be, maybe the lawyer was doing it, or maybe the security person was weighing in on it. This is a big reason I came into this particular company much earlier than I have in other companies. The recognition of the need for this function, which goes across all the other functions of the company, has become greater. And that's because of things like this, where every decision has layers and nuances to it, and it's not so simple. That starts sometimes with, in many cases, the sort of GDPR prep that you're doing if you're a global company and you're listing out all of your sub-processors, and you're doing records of processing activity, and you're starting to document all of the systems that you're using that touch and process personal information. So then, Maureen, go to your question, it's like pretty much an individual analysis of each of those and what's going to happen when data flows or doesn't flow through to those. So it's a big decision, and I think it's probably going to lead a lot of people to figure out or attempt to figure out how to take the position that they don't sell.
Yeah, Maureen, if you don't mind me pushing a little bit on the consumer expectation, just because you're the moderator, I don't think you get avoid the hot seat, but what is that consumer expectation, right? If a consumer goes, let's say, to Nike and buys a hat, a running hat at Nike, and they might expect that Nike will reach out to them via email. If they didn't say, opt me out of emails, they might expect Nike can reach out to them via email or send them a message advertising the next thing that Nike wants to advertise. And I don't know that the consumer wouldn't expect that Nike will reach out to them when they're on Facebook or Twitter as well. When we think about sending a text message to you, sure, Verizon or somebody else might carry the message. We don't think of that as a disclosure to Verizon. The CCPA doesn't make Verizon, someone who you sold the data to in order to deliver the message. So I don't know why Facebook or Twitter, as a platform that helps Nike deliver its message to you, is outside the consumer expectation. I understand you might not expect that a third party advertises to you based on the Nike hat, but shouldn't Nike be able to find you while you're on Twitter and Facebook, just the same way they can find you by sending you an email?
I mean, just from my perspective, and it may be different from what the average consumer is doing, but it's been really frustrating to go to a site, Amazon or Spotify, and try to opt out, and they'll say, well, we don't sell your data, but we actually share it with advertisers to continue to show us ads. So that's causing some cognitive dissonance that feels frustrating.
One thing that I consider is, the set of principles that I've enforced for BBB national programs is a notice, choice, enhanced notice, and special protection regime. Similarly, CCPA is also built around notice, choice, and special protections. And I do wonder, if you're looking at the average, ordinary, reasonable consumer, what their actual engagement is with opt-out tools. You can have the best opt-out tools in the world placed in the best places on your website, on your app, and I think it's hard to identify what the exact consumer expectation is, even when you have those tools built into your web experience or your app experience as well.
Yeah, I mean, this is kind of a separate point, but related. But another frustrating thing that consumers experienced when doing opt-outs is that they'd be asked to download a third-party app in order to opt out. For example, to get their advertising ID. And I mean, this just blew consumers' minds to have to go through all these separate steps in order to opt out. But I think, in this case, the information was tied to an advertising ID and not an email. And I don't know if that's a worse, approach than to having it tied to the email. So, I mean, there are some limitations in the law itself, I think, in terms of consumer workability. And
how much can we expect from consumers when a lot of people just want a seamless, fluid web experience, and they might be concerned about privacy, but they also like the fluidity by which they move across the internet. And I do wonder if there's some tension between the ideal of really good and really effective opt-outs with the way that consumers actually engage with the web.
And do you have recommendations for a better approach?
No, I think it's a difficult question. I don't have any good answers. If I had a good answer, I'd probably be much more successful than I am. But I think one thing that I think about, and I think this metaphor is a little bit outlandish, but bear with me. Think about space travel, right? So 60 years ago, we landed on the moon, and there was that immense achievement. And there, in the imagination, it's like, okay, we landed on the moon. We're going to go to Mars. We're going to go asteroid mining. We're going to have moon colonies. Similarly, I think when these big pieces of legislation were passed, GDPR, CCPA, I think we thought there'd be really big advancements around privacy that would move us forward. But then we got to a place where we're still dealing with some of the realities of the web, the realities of space. When you're going up in space, there's a reality of radiation or escape velocity, what have you. In the world of privacy, there's a reality of how consumers move across the web, how content is monetized around the internet, the tension between good transparency with your privacy disclosures and being too overwhelming with what you're presenting to consumers. So I think right now we're at a stage where we're trying to address those questions and craft good self-regulatory or regulatory standards around that, given the really deep challenges of some of these some of these issues.
I agree with that. One of my peccadillos, or whatever, however you want to describe it, is I always feel like there isn't enough attention being paid to user experience. And maybe that's because I work with tech companies, but like consumer user experience around an opt-out or around any sort of privacy policy, viewing of that, being told or explained what's happening with their data is so bad. I write privacy policies, Mark writes them, I know, like they're not fun to read or write, or they're not interactive, they're not interesting, they haven't been innovated in. Nobody's thinking about that UX, right? And I think one thing that could benefit the consumer is a little more attention to UX and a little more attention to like, what's my experience like when I'm getting this web content or this connected device? That's going to happen more and more as these things become more and more popular. And I think I always thought when some of these laws would pass that we would get a little more attention to what that experience is like with the data subject or the consumer. And I don't think we've gotten there. I think we've just gotten another layer of privacy regulation, another set of requirements for companies to deal with and go through. And the bigger platforms have all this bandwidth and firepower to deal with these. And so they will keep going because they have the ability to withstand things, to take positions, have enforcement challenges and push back against those. And so I just think we're in this sort of place where I don't necessarily know if the consumer yet, I want to be positive and say just yet, is really getting better privacy at this point yet.
And we can't expect every consumer to be a super user and kind of employ like some of the detailed technical capabilities of a web browser or a mobile app or settings within a mobile operating system. And I think balancing consumer technical sophistication with really good UX with the regulatory and the self-regulatory requirements is a very difficult thing to do.
The thing, the observation I'd make, and I think it might transition us to our next discussion about the CPRA and Justin's question is, this is a privacy statute, and we're applying it to advertising. It is not an advertising statute. And laws about privacy are about the disclosure of data from one party to another. But consumers don't really care whether it's first party or third party advertising necessarily. You're talking about a law or a structure that would change the consumer's experience. It's so difficult to do that with these statutes that are about disclosing data for advertising purposes versus just a consumer seeing an ad. And I'll give you the example. The law treats it differently whether a platform takes the data about the consumer and gives it to a third-party advertising, that may be a sale, versus tells the third-party advertiser, I can target an audience that's exactly the right audience you want, but I'm not going to tell you anything about them, but I have them in a segment to come target them on my platform. Same exact consumer experience. The consumer is seeing the same exact ad in the same exact way. In one way, data passes, another way, data doesn't. This law is about the data passing. It's not about the advertising generally. And so when we talk about the CPRA and how it changes things a little bit, but still not that much with regard to that question. The consumer's still going to see an ad, and they can still be targeted based on the segment they're in. It's just a question of whether or not the data about them gets passed or doesn't get passed.
Great. Well, let's follow up on that. How do you expect CIPRA to change this space, if at all?
So I don't want to hog too much airtime, but I have a thought. Andy,
go ahead, Mark.
So, I think people behind CPRA would take the position that it stops all behavioral advertising and it stops retargeting. And the reason they take that position is because instead of sell, we have sell and share. And we have a definition of cross-contextual behavioral advertising that really does look like it's designed to stop OBA, third-party advertising. It's not 100% clear to me, however, and I would make the argument that it's not intended to stop first-party advertising. And the definition of cross-context behavioral advertising is targeting of advertising to a consumer based on the consumer's personal information obtained from the consumer's activity across businesses, distinctly branded websites, applications, or services, right? So any information a first party has about you, they can still advertise to you based on that because it's not their activity across businesses or differently branded websites. So when you get to the question of retargeting, Maureen, you come to visit obviously I'm a law firm, but one of my clients' websites, you give certain information to them. They have a variety of different sites. They know things about you. They want to target advertising to you. Again, they send you a text message. Fine, that's not cross-contextual behavioral advertising. It's only about what you do on their site. They send you an email, not cross-contextual behavioral advertising. When they find you on Twitter and say, go to Twitter, find me, Maureen, and they find you and they get you a Twitter message, it's not cross-contextual behavioral advertising. The information they have about you is from one context, their site. They only learned it about you and from you and no other site. Why can't they retarget you? I don't see why the CPRA necessarily blocks that. You'd have to say the platform is the other context, but that doesn't make sense. Verizon is not the other context when we send you a text message, and your email service provider isn't the other context when we send you an email. So I'm not 100% convinced that the CPRA as written stops retargeting on a true platform. On a publisher's site, maybe, but on a platform site, I'm not sure.
And even assuming the statute CPRA, as it's expanded the definition of sale or supplemented it with the term share, I do wonder, given that data collection for advertising is such a fixture to the web in terms of access to low cost content, I don't see us moving toward a full subscription-based model for content, a micropayments model or a crypto mining model or whatever, just anytime soon. I just don't foresee that. And when the statute is enforced, either by the California AG or by the new California Privacy Protection Agency, as the matter of the actual enforcement, are they going to be going after everybody that's going 5 miles per hour over the speed limit, or are they going to be going after everybody that's traveling, only the people that are traveling 120 miles per hour on the highway or faster? And I wonder how that reality of the enforcement, again, is going to reflect the actual compliance with the statute, even once CPRA comes into effect.
So it seems like folks are skeptical that CPRA is really going to change the ad tech ecosystem.
Well, Mark's answer is pretty nuanced, right? I mean, there's platform advertising and there's open web, right? I mean, there's a lot of money spent on programmatic open web, ton of it, and there's questions right out there about that and about doing that. And they're also, having been in the ad tech industry, it gets really nuanced really fast in terms of how the data is being used by that ad tech company, where they're creating graphs and doing things, such in order to better serve an ad. And so I think the answer, Maureen, is unfortunately probably similar to what we've said before. Is I think, and it sort of relates to what you just said, Ayaz, like the market power of advertising is so big and so meaningful.
Right.
We saw this with the GDPR. The market power is so powerful and meaningful that to slow that wave down takes a lot, and it takes people being put in, I would say, arguably impossible positions to stop that from happening, especially when you have big platforms enabling advertising.
Yeah, and I didn't want you to misinterpret my answer. I do think it'll make a big difference. On the limited question of retargeting, I think it's unclear. I think what it really does is there have been a lot of organizations that are trying to solve the CCPA problem by saying you can be a limited service provider for these purposes, and you're really a service provider of either the publisher or the advertiser. It gets rid of all that. I mean, the CPRA makes clear that behavioral advertising is covered, not just what, let's say, the IAB considers to be a sale today. It's saying it's all covered. I'm just trying to carve out a little nuanced space for retargeting isn't necessarily cross-contextual behavioral advertising. But I do think it will make a big difference to the eco-structure. Not as much as some of the private things we're going to talk about in a minute, perhaps, Privacy Sandbox and iOS 14, but it's going to have an effect.
Well, let's segue into that. What are some of these things that companies are doing that's affecting the ad tech ecosystem, with an eye towards privacy? And are things getting more? Is privacy served by this? Is it going to achieve privacy?
Well, I think what's interesting about Privacy Sandbox is that's an example of Google's dominance in the Chrome with the Chrome browser in the browser marketplace, giving it the ability to affect major technical changes which affect a lot of its users. But I think what's interesting about Privacy Sandbox is the various models they've proposed: turtle dove, sparrow, flock. They have all bird-sounding names. What's interesting, I think, with turtle dove is, and a lot of these are largely theoretical, but as I understand it, with turtle dove, they're going to try to move the calculations for interest-based advertising from the server side to the client side. And I have questions about to what extent that'll take up computing resources on the user side, or if that might disrupt their experience, and what that'll actually look like in reality. I think the Trade Desk proposed more of an identity resolution model, and I think with something that might be a little bit more deterministic like that, there might be privacy challenges that arise from there. So I think even if you're reconfiguring these environments away from cookies, there might still be it's not going to sort of solve the question of people of consumers having legitimate concerns about privacy, because there's still going to be data collection for advertising taking place in these environments.
You have Greg in our chat saying, I hear regularly the frustration about I searched for X and now everything I open shows me X. That doesn't go away. You can change the tech all you want. The internet's the internet, and you're going to be retargeted for a pair of shoes. Forever. If you want free content, you're going to be retargeted for a pair of shoes. And I always sort of come back to I admit that I don't understand the frustration. And maybe it's because, in your law school, you get pounded with this concept of damages. Like, what's the damage? How is the person damaged? I see Greg's, in the chat here saying that it's frustrating. So what is frustrating? What is frustrating about visiting Amazon and looking at something and then seeing it later? Is that frustrating? Or is it just, does it feel unfair? Does it feel somebody is using their data in a way that they weren't aware of? Does it go to UX again? Should they be explaining this better to consumers? I honestly don't know. But I think these questions will remain irrespective to me.
I mean, wouldn't you say, so we haven't really touched on, but wouldn't you say if we're deprecating third-party cookies and we're getting rid of those by 2012, we're going to put a lot of advantage to those people who have significant amount of first-party data. And so the push will be to collect more data from consumers in the first-party context in order to be able to provide them, to make up for what you're not getting in third-party cookies. And so in some ways, you'll be protecting consumers' privacy because their data will go to fewer people, but more data will be collected by the first parties, I would think, in a no third-party cookie environment.
I think there's going to be sort of a life finds a way response to this in that even if you remove some of these technologies, if we're going to have an internet where you have low cost access to content, that internet's going to inevitably be monetized by advertising, and there's just going to be new technologies that might be somewhat less invasive or that are going to facilitate, where we might just end up returning to a set of problems which are broadly the same.
And you have the sense that some of these, changes proposed by Google and Apple will benefit them exclusively at the expense of other companies?
Well, with iOS 14, I do wonder. I think Apple is trying to position itself as a privacy brand, and I'm sure they're making part of the reason they're going to make that change is the result of them making a good faith effort toward being more privacy protective to their consumers. But on the other hand, some of their major competitors have a larger advertising model that their profits are based off of. So, that I just speculating, that particular change with iOS 14, that could be motivated by multiple interests rather than completely the notion of being maximally privacy protective toward their stakeholders.
One misnomer about iOS 14, I don't think that people listening to this probably have that misunderstanding, but the idea that it's all about the IDFA and the IDFA goes away and that's
Yeah.
not the change in iOS 14. It also requires tracking consent for the sharing of any non-Apple data obtained through the app with third parties on a cross-developer basis. And that's going to dry up a lot of advertising in the mobile industry. Right. I mean, some people say half the US market on mobile advertising, which is going to cause us to sort of bifurcate in this area where people will have an authenticated experience, right? And that's the way, once they're logged in, authenticated sites will be able to collect data. And it's going to be harder to monetize the non-authenticated experience. And back to Andy's point about the UX at the beginning, it'll cause more friction. It'll break some of the UX that consumers did like, where they could go seamlessly from one place to another because the data was being passed behind the scenes in a way they didn't object to because they wanted to have a certain user experience that they won't be able to have. So
it would be much worse than what we worried about with cookie fatigue in Europe. A lot of clicking, a lot of accepting. It's going to be way worse. And to the prior question, you'd have to be speculating here, but also my practical brain tells me that Google is the largest competitor of Apple.
Right. Exactly.
Well, okay. I mean, it's a pretty big deal, and it's a pretty big head-on shot. It just is. That's directly hitting Google.
And what about the global privacy control? This recently introduced, it's still in an experimental stage, standard to make it easier for consumers to opt out at multiple companies. What kind of challenges will that raise with respect to compliance? Do you expect that to have a significant impact on the market?
Well, I suppose, as I understand it, that standard has been adopted by the Brave browser, maybe a couple other of the smaller browsers, and it's incorporated into some browser extensions, as I vaguely understand it. And I think the California Attorney General signaled, and the regulations signaled that that type of tool could be used to effectuate a CCPA opt-out. I guess it returns to the question of, are enough users and are enough publishers going to buy into this particular solution as part of their compliance strategy or part of their personal privacy protection strategy? I guess that's what comes to mind initially to me.
It's reminiscent of the do not track wars. Here we have a statute now that says for people covered with the CCPA, they have to honor that signal sent by the browser. Are they going to honor it? Are companies going to honor it for non-California residents? Or are they going to say there's not enough volitional aspect? Sure, the consumer chose to use the browser, but they didn't really choose to turn that setting on. It was a voluntary act. And do I need to honor it outside of California? It gets adoption if other states pass laws that require them to, accept that signal. Nobody wanted to accept a browser-based signal under CCPA or before CCPA, and CCPA is forcing their hand on that.
Mm-hmm.
So you're kind of interested in seeing how much adoption there will be, before you could assess the impact on the market.
Yeah. Until Google adopts something, I don't.
Right.
It's such a large piece of the advertising market. I mean, it's in some sense, you need to see how they're going to act.
And let's shift to one of the questions in the Q&A from Susan. Facebook's limited data use flag and recent changes to their terms has significantly impacted how brands and business work with Facebook. Have you seen any companies successfully negotiate for Facebook to act as a true service provider without sacrificing core functionality for their marketing objectives?
I haven't negotiated.
Yeah, I'm going to pass it on to my colleagues here.
I've seen, Facebook has divided its services to the ones where they are acting as a service provider and the ones where they're not. And, our clients who, I'm going to broaden this beyond Facebook just to talk about all the entities that do that. Our clients don't have the ability necessarily to pass the signals on a consumer by consumer basis. So a lot of them have been forced into the question of turning it on for all California residents and treating it as a limited data provider for all California, or nationally, which they're not doing, or all California, or not using that service. And they're all rushing to, this is where I'll give a shout out to Wirewheel for having a technology solution here, but to adopt management platforms that will allow them to send the signals on a consumer by consumer basis, because without that technology, they're stuck and turning it off for the state. So we've had clients, come to Wirewheel and other entities to try to build that so they can do it on a consumer by consumer basis. But the question is getting Facebook to change their position with regard to other services that they're not agreeing, like custom audience, to be a limited service provider for, and agreeing to do it. I haven't seen that.
Great. And one of the other questions I had was with respect to the non-discrimination provisions of the CCPA that came under a lot of controversy, both from the consumer advocacy perspective, who wanted it to be stronger, and from businesses who, were not happy with that non-discrimination language in the CCPA. So I was wondering if you have seen any impacts in the market as a result of that language.
So I've seen a lot of confusion, and the confusion I've seen is the statute and the regs seem to contemplate financial incentive differently. And personally, I think the Attorney General's office got it a little bit wrong when they issued the regs, because the regs say that a business that offers a financial incentive or price or service difference shall provide a notice of financial incentive in accordance with the CCPA. And then the way in which the AG's office put those regs into place, it makes it pretty unclear that if you offer any service for free, is that a financial incentive? Is just offering a service a financial incentive, that you're not charging consumers for the service because you're getting some use out of the data? It seemed to me that the point of the notice of financial incentive was to say there's a price or service difference for people who give us more data. We valued that at $5. Here's how we valued it. It's reasonably related to the value of the data. Here's the price or service difference. But I think companies are trying to figure out, it makes it look like any time there's any incentive provided to consumers in which you're collecting their data, you have to provide this notice. So I've seen companies go kind of all over the map on this financial incentive notice. Many are not giving one, and some are giving one when it doesn't seem like they need to give one. So I think there's a lot of confusion here. I'd love to hear what Andy and Ayaz think in the market, or what you think in the market, but I've seen considerable confusion over when a financial incentive notice is needed.
Yeah, not just the notice, just the whole provision. I mean, when I first read the CCPA, that was one that stood out. And I just said, I don't understand this. I don't understand how this is going to be practically put into play, how it's going to work. The regulations didn't help. So I just think, we're going to need more. We're going to need more information, more context. We're going to need some help. There's a bunch of areas where we're going to need comment and help. Like, I just don't think it's, whether you're all over the map or not, I don't think we have much to go on there yet.
And I don't have much to add. I concur that I think there just needs to be some additional clarity on that point. And I don't think the regs really, as I read them, really added additional clarity on that with respect to this issue.
And do you think CPRA helps in that respect? I mean, my read of it was that it doesn't meaningfully change the CCPA in that respect. Wondering what other folks think about that.
Maybe the regs will, but yeah, not yet.
Right.
And Andy, what are some of the other things or areas that you think need clarification?
Should we reverse the question?
What doesn't?
It's pretty unclear. It's pretty unclear in a lot of ways, and it's hard to pick one per se. And if I'm just thinking about advertising and marketing, it's also hard to pick one. But I think what would be really helpful would be that if we got some real true clarity on sale, and that if sale was actually a sale and wasn't every single thing that can be done with data and making data available, or we at least got some clarity around making available, and what does the context of that look like. Does that, it doesn't have to go into deep questions that I may have if I were having a drink with Mark and talking about integrations with systems and making data available through integrations. Those are complex decisions or complex discussions about data, surfacing data. Even just, could we get some clarity on a few ways in which making data available maybe isn't necessarily a sale, or can we come closer to the idea that I'm actually selling something?
And just to take up Justin's question, he'll have the chance to talk to Alistair later. What questions would you ask him to better understand the CCPA?
To take Andy's last point and drive it home in a question for Alistair, I'd ask him, when I am paying somebody to perform a service for me, like I am giving them thousands of dollars to do something for me, I'm giving them money, they're giving me the service, even if they don't sign up to the service provider provisions exactly as the CCPA requires, why is that a sale? That's Andy's real question. Just because I make data available to somebody, if the benefit isn't flowing back to me other than the service they're performing, it's not for the data, why is that a sale? Now, I think he'd say the new CPRA has this new contractor provision that solves this a little bit, because it had service provider only, now it has service provider or contractor, but it doesn't solve the essential sale question. But that is not a sale of data, that is using the data for a specific purpose. I think that's one of the questions we should ask Alistair on the sale point. On the financial incentive point, it seems to me that the goal of this, again, was to be a price or service difference, where I'm discriminating against somebody or providing a different level of service based on the data they're providing to me. That would make the statute a lot clearer to understand. Here's a free level of service, here's a paid tier. At the free level, there's a financial incentive. Here's what it is, here's why. But that's not the way it's written. So I want to know what else he wanted to cover by that, because I understand they had a lot of thoughts on that. What did they want to cover other than the price or service difference?
I think I'd be interested in his take on whether he thinks consumers have enhanced privacy, actual privacy, or whether they've been given a boatload of rights that are difficult to understand and difficult to effectuate and difficult to enforce, and companies are being put into heavy scrutiny, enforcement challenges, things like that. I get it. But from a consumer's perspective, does he feel that, today the consumer has really, really meaningfully increased their privacy? I don't know.
And I suppose I would ask, even outside of the issues of statutory interpretation, I would be curious as to what his perspective on the ideal state for privacy should look like, even beyond what the statute and what CPRA will achieve. I'd like just getting a sense of what that ideal outcome, what does it look like at the end of the story? I'd be interested in hearing a little bit about that.
And I'd be interested in getting another explanation of what contractor means, because I'm still very confused about that. Well, that is all the time we have here today. I want to thank the panelists for this really fruitful discussion and turn it back to Mark.
Thank you.
Great. Thank you, Maureen. And thank you to all of our panelists. That concludes this session. Thank you all for joining us. I'd like to remind everyone that recordings of this and all the other spokes sessions will be available after the conference concludes. On your screen, you should see in a moment the agenda for the rest of the day today. But the next session, which starts in about 10 minutes, will be Women in Privacy at 5 o'clock Eastern. So we hope to see you there. Thank you all very much and have a great day.